Tell One, bringing you together.
Our viewers of Entrepreneurship TV, welcome to today's program. In today's program, we've got Chiedza Shoniwa. She is a commercial lawyer. She's back again to talk to us. This time, she's going to talk to us about labor law. Chiedza, welcome to the program.
Thank you for having me.
Chiedza, we have discovered that a lot of entrepreneurs and business people tend to struggle when it comes to labor law. We want to discuss with you and maybe make sure that our entrepreneurs benefit from your legal expertise.
Okay.
What is labor law?
Labor law, you're looking at laws that regulate relationships between an employer and an employee. You have, for example, your constitution, and also you have like the Constitution of Zimbabwe in the case of Zimbabwe, and you have your Labor Act. You also have regulations that flow from the Labor Act, mostly to just regulate the relationship between the employer and the employee and to safeguard the interests of both parties.
I know you may have partly answered my second question, which was going to talk about who is governed by the labor law. Would you want to briefly maybe explain on that?
Okay. So the labor law governs an employer in terms of the rights and obligations that they have as an employer. And also it was created to protect the rights and interests of employees. So it also governs employees, people who are under employment and receiving remuneration from someone else, being the employer.
If we're talking about business and running of companies, one definitely cannot avoid the issue to do with labor disputes. In the event that labor disputes do arise, how are they resolved?
And unfortunately, before answering directly to the question, people tend to just wake up and they have a dispute with the employee or with the employer, but then they don't follow the proper process or procedures set up. And they either fire a person automatically or just tell a person not to come to work. So now if a labor dispute then arises, let's talk about company level. At company level, though each company is within a different trade, the first port of call is their code of conduct. You go to their code of conduct, it stipulates procedures that should be followed. But they're different code of conduct. But generally, a code of conduct would stipulate that an employee at least has the right to be heard. So they have to set up a disciplinary hearing that is procedurally fair and substantively fair as well. So you start from that level and there's a hearing that actually takes place. And then now, if the employee then gets dismissed, let's say at the first level, they can appeal, still at the company level, they can appeal against whatever decision that was made at the initial disciplinary hearing.
Our viewers across the globe, please stay with us. We're just going to go for a very short break. When we come back, Chiedza is going to talk to us in terms of what are some of these rights that are supposed to be protected and covered through labor law. Our viewers, welcome back. Chiedza, welcome back. In the initial first segment, you spoke to us in terms of what is labor law. Now, I would want to understand from you, what are some of the rights and or benefits that are covered through or by labor law?
There are a number of rights, but differs from employment in terms of trade, as I'd said before. So it's different from employer, and it's different in terms of the trade. But one of the common rights that are covered is if you're going to retire, the age of retirement. It's stipulated in our labor laws, and also benefits. If then you say you're now out of employment, what are your benefits, your exit packages? And then also an employee has a right against discrimination. So it also covers the part of discrimination. Your leave days are covered as well, because they know that some employers wouldn't allow an employee to go on leave or to even take time off. So the labor laws also talk in relation to the number of leave days. For women, you also have maternity leave that also is covered in terms of the labor laws. So at least there are certain issues that you can't argue against, or you can't contract and diminish them. They are already set up, and it's a right for the employees in terms of whatever it is, it be leave days. It's a right set up. You can, however, enter into a contract with an employer, and they give you better rights, but they can't give you less rights than what the Labor Act stipulates that you should have.
We have had instances where companies' ownership happen to change hands. And
Yes.
in those instances, a number of employees have complained in terms of some of their conditions being varied or changed. What happens when a business changes hands?
When a business changes hands, or when there is a business sale, the employees automatically transfer to the new owner. Be it either the business was a share sale or it was an asset transfer, but it's automatic that the employees then move to the new owner. But now the relationship that is there, because they already had their own employment contracts, they can sit down, negotiate on new terms, and an employer can vary terms of an employee's agreement with the consent of the employee. So they can't do it unilaterally. An employer can't come and enforce a term or enforce anything on an employee without the consent. So there has to be a meeting of the minds for us to say there's an actual agreement between the parties. So sometimes they engage the Works Council to carry out the negotiations and stuff. But as I said earlier, even an employee can't even consent to the diminishing of their rights in terms of the Labor Act. They can't. There are certain rights that still remain. That's your retirement benefits, social security, and they go on. But certain rights that are stipulated, even a new owner can't negotiate them downwards or diminish them. And also looking at, let's say, the sale of a business. The new employer can't come and then terminate the contract of the employees just simply on the basis that they're now the new owner or whatever, with no reason. It doesn't stand that it's automatic that then they can just dismiss the employees who were there and the business sold.
My last question in this segment would want to hear from you in terms of termination notices. I understand we've got various employment contracts.
Yes.
How do employers go about making sure that they've legally terminated these contracts?
Okay. The contracts that you have, if I can just say but a few, Let's say you have your employees who are engaged on an indefinite period. There's no period whatsoever, or they're engaged for a period of 2 or more years. Then now the employer has to give them a notice, a 3 months notice period, to actually say, you know what, I want to terminate for whatever reasons. And then you also now have your employees who are engaged for a period of a year plus, but less than 2 years though. Then those employees should be given 2 months notice. Then also it stems down as well to employees who are now engaged for a period of more than 6 months, but less than a year. Those employees, you give them 1 month's notice. And now you have your 2 weeks notice, which you give an employee who is engaged for a contract for a period of 3 months or more, but less than 6 months. Then now you have your 1 day in the case of a casual worker or a seasonal worker. And this is a person who's engaged for less than 3 months. But there are different types of employment contracts, as you have seen. The casual workers or seasonal workers, the workers that are engaged for an indefinite period, those are your different type of employees. And some contracts actually stipulate the notice period that should be given. And if you, by reading of whatever contract that an employer and an employee have, you can actually see which notice period will apply, if at all.
Our viewers across the globe, please stay with us. We're just going to go for a second break. When we come back, we'll have entered our final segment of the show. Please stay with us as we go for a very short break. Chiedza, welcome back to the third and final segment of our show today. I understand you have talked to us in terms of various contracts, in terms of various notice periods that are available. Now, I would want to find out from you what sort of contracts of employment which are covered by the labor law.
The labor laws, they cover all types of employment. If a person is receiving remuneration and is considered an employee, they are covered by the labor law. From your seasonal workers or casual workers to workers that are on fixed term contracts, specific periods, to workers that are employed for an indefinite period, they are covered. And also, there's nothing that says an employment contract should be in writing. So a person can say because there's nothing in writing, then you are not covered because you're not an employee. That doesn't work. They're what we call implied terms that come into effect. And it's there to protect employees even in a situation where there are no written contracts of engagement, but it's actually to cover them as well. So all types of employment employees, are covered in terms of those laws.
Chiedza, you have talked about other employers and employees being in a situation where they may not be having written contracts. Are there any advantages or disadvantages when employers and employees get into an employment relationship without writing down contracts?
Yes, there are challenges, of course, that can be faced. Especially the disadvantage comes on the part of the employee. Now, because a written agreement will allow, it makes it easier for if you have an issue with your employer, or even if the employer has an issue with the employee, to go back to the agreement and say the reasons why you are engaged, what's expected of you. It's there in black and white. And then if the person fails to then follow up what is expected of them, whether it's the employer or employee, they can always go down to the written agreement and say, you know what, this is the issue that we have. But now if you have an agreement that is just by word of mouth, and now you're saying you haven't paid me, if it's in the case of an employee, you say you haven't paid me for 3 months or 4 months, and now I want you to pay me, and you want to bring your dispute to the relevant authorities, then you can't. You can, but it's difficult now if you come and say I should have been paid 2,000, and then the employer comes and says, no, we never agreed to 2,000. I said I'm going to pay you 500. Now it's now a he said, she said scenario. And then you end up fighting, taking more time than just going back to the agreement to say, what does the agreement stipulate? And what is the agreement saying? So it's a disadvantage when it's now an issue where there's a dispute that arises, whether on the part of the employer or on the part of the employee. So I highly encourage people to have agreements in writing. So it just makes it easier. But even if there's no agreement, still there's an employment relationship, and there's a recourse in the event that either party is disgruntled over a certain issue, and they can find a solution through the relevant channels.
Chiedza, without maybe unnecessarily consulting on behalf of the viewers, we are faced with COVID-19 pandemic, and I happen to be an employer. My business has not been generating enough revenues, and I would want to reduce the salaries or wages of my employees. Can I unilaterally do that?
And unfortunately, you can't. As I said previously, you need either the consent of the parties involved to say this is the situation, there is COVID-19, and we are not making money. So what can we do? Let's see, can we reduce, or what can be done? There always has to be an engagement. But now without an engagement, you can't wake up and say, I think if I'm paying people 5,000, I'm going to reduce it to 1,000 because that's what's there in terms of our accounts or what we have made this month. It might be the situation, but then you can't just automatically on your own do that because that's unfair. And the labor laws are there to guard against unfairness. And then now in those situations now, I think it will be something we'll discuss. You'd have to consider retrenchment, for example, in such situations where you say there's a real need and the business is suffering. So how to move forward?
Chiedza, we are very grateful. My last question then in this show, and the final question for the show today is, if an employee is deemed to have been dismissed unfairly,
yes,
is there any recourse, and what is the recourse available legally?
Okay. If an employee is deemed to be dismissed unfairly, firstly, if the employer has followed the proper procedures at company level, it means the employee has been given a platform to be heard. So there has been a disciplinary hearing, and they have appealed against whatever decision that has been made at the disciplinary hearing stage. And even after the appeal, they still feel like, you know what, there is still an unfairness on the part regarding whatever they feel like is unfair. They can then approach either a labor officer, or they can approach a designated agent of the National Employment Council. and then they bring their complaint there before them. So now that's the recourse that they have. But everything has time limits. So they shouldn't then sit on their hands and wait, because there are certain disputes that prescribe, and also they should take that into consideration. So they should act fast. And then now, if they bring their matters before the authorities I've stated, it always also differs from one sector to the next. The transport sector, they have their own National Employment Council. The mining sector has their own National Employment Council. So you should know, like, within the sector that you're within, like, where do you go? But that's not a difficult situation. You just ask for assistance. People will help you. They will advise you where to go. And then from there, they take the matter, they do the hearings, whatever it is that they need to do, and they come up with their own rulings. Depending on the nature of the ruling, they go to the labor court, either for confirmation or whatever processes that are required. And if it relates to money, or you have been awarded damages, then the issue then either goes to the High Court or the Magistrates Court for issue of enforcement. Because now, if you want now the employer to then pay you and they're refusing to pay you, the person that you can look for is either, if depending on the money involved, so the monetary jurisdictions of a court are of concern, then you either go to the Magistrates Court or to the High Court, so that you can enforce that and you can get your money from the employer.
Chiedza, thank you very much for the time you have come to share with us. We will always rely on you in terms of all the legal expertise that we require on this platform. For those that have been watching this show, please continue to subscribe on our show. Chiedza will be coming back more often, where we are going to be discussing a lot more legal matters. Please continue to subscribe, as I've said. Chiedza, once again, thank you very much for your time. Look forward to seeing you again when we are going to discuss future legal issues.
Thank you so much for having me.
Thanks.
Tell One, bringing you together.